Hi, I'm attorney Deb Stevenson again, here to answer some more questions about homeschooling.
So in the previous video you talked about doing an opt-out procedure if you are sending your 7-year-old to school, to a public school, but you don't want to start till they're 7. So what if you signed that opt-out and when it's getting to the age where they are supposed to be enrolled in the public school, I change my mind and I want to homeschool? What procedure do I have to follow?
Well, since you already filled out an opt-out form, which effectively withdraws the child from enrollment in a public school, or declines enrollment in a public school, they are not enrolled in the public school. So therefore, you are free when they turn age 7 to decide to undertake the obligation that you have under state statute, Connecticut General Statute 10-184, to bring your child up in some lawful employment and instruct them in the subjects listed. So you are free to choose to do that, and you do not have to seek anyone's permission to do that. You do not have to go to the public school. You do not have to sign any more forms. You do not have to go to any kindergarten screening or anything like that. You simply undertake the obligation that you already have under Connecticut General Statute 10-184 and begin instructing your child at home. Any other questions?
Yes, so what if kind of you have the reverse where you have an under age 7-year-old who is already enrolled in a public school program, preschool or kindergarten, and then you decide you want to homeschool them because they're not compulsory age yet? Is there a different procedure?
Well, in that case, because the child has already been enrolled in a public school program, whether that's a one-day program or even something less than that, part-time, whatever it can be, a preschool, whatever, because you have actually enrolled in a public school system for whatever purpose, we do recommend that you officially withdraw the child. And again, I'll go back to what I indicated in the first video, how to do that, and that is you write a letter, keep a copy. The letter should say something to the effect of, my child, name and age, as of whatever date you choose, will no longer be enrolled in the public school district. My child will be instructed in accordance with Connecticut General Statute 10-184. Keep a copy, send one certified return receipt mail to the superintendent of the public school district. You can send a copy to whoever's running that preschool program if you want as a courtesy, but make sure you do send a certified return receipt to the public school district. Do you have any other questions?
Yes. The school district told me I have to file the notice of intent or else.
Well, the school district may think that you have to file the notice of intent, but again, as I indicated, notice of intent is a suggested procedure. It has never been adopted as a state statute and never been adopted as an administrative regulation. The notice of intent, sometimes what will happen is the secretary or the people working in the public school district will not really understand the difference between something that the local public school has adopted as its own regulation and as its own policy, not regulation. It was never adopted as a regulation because policies do apply to those children who are enrolled in a public school. However, once a child is no longer enrolled in the public school, the public school district policies do not apply and are unenforceable. So there may be some misunderstanding on the part of the school district who says you must file a notice of intent or else. There is nothing in the statute that requires a parent to file a notice of intent. You may do so if you choose to, but you are not required by law to do so. And thanks for listening, and we'll be back soon.